Okay, so a sitting U.S. senator just asked a federal judge nominee a simple question. If a president orders Navy SEALs to kill his political opponent, is that a crime? And the nominee, the guy about to sit on the Eighth Circuit, couldn't give him a straight answer. Watch. That was Adam Schiff last Tuesday, and it somehow gets worse. If you want the full breakdown, stick around, hit subscribe, because what comes next should concern every single one of you.
I believe that a lot of the corruption that we're seeing in the administration and the White House traces back to a single decision of the Supreme Court granting the president immunity, absolute immunity when it comes to certain core functions of the executive, a qualified immunity as to other official acts. The only area where a president would be personally liable for prosecution would be purely personal conduct, which is hard to imagine what that entails given that the president is president 24 hours a day. You were part of the president's legal team defending the president, articulating the president's position in Trump v. United States. I want to ask you about that. In the Court of Appeals, John Sauer, one of the counsel for the president, was asked by a Court of Appeals judge, Penn in the D.C. Circuit, whether under your theory of the case, his theory of the case, a president could order SEAL Team 6 to assassinate a political opponent and not be subject to prosecution for it. Sauer's answer was effectively, that's right. Unless he were impeached first, he would not be subject to prosecution. Is that your view as well?
I think a similar question was also asked at the oral argument at the Supreme Court a few months later. I think the Supreme Court has now set forth a test in Trump versus United States that would address that hypothetical situation, which, based on my relationship, I might add, I think is outlandish, and I see no reason to think that that hypothetical would ever be a possibility.
Well,
but
so is it your view as well, as it was Mr. Sauer's, that yes, the president could assassinate a political opponent and not be prosecuted for it if his party won't impeach him in the Senate?
I think Trump versus United States that you mentioned, Senator, now has addressed to some extent the impeachment judgment clause, and that is set forth in the opinion. It would be something that I would be bound as precedent to apply if I was to address.
With my hypothetical, what's your answer? The president orders SEAL Team 6 to kill his political opponent, one of them, maybe several, uses the military to do it, so it's within the scope of absolute immunity. Is it your view that he is not subject to prosecution for that if the members of his party will not impeach him?
With that hypothetical or any hypothetical that you might try to pose, Senator, I would just refer to the test that the Supreme Court has set out.
I'm asking you your view, so just tell me yes or no.
Yeah, and I want to tell you that as a judicial nominee, I don't want to prejudge any case, regardless.
Well, I'm not asking you to prejudge. I'm asking you to talk about your view and also what you argued, what you counseled the president in that case. Did you make the argument as a member of the president's legal team that, yes, he could assassinate his opponent if he used the military to do it, and if his party wouldn't impeach him, that he would be protected?
Yeah, so I can't get into any privilege conversations, as you know, due to attorney-client privilege, but I would refer you to the remarks that John Sauer had at the Court of Appeals and the Supreme Court.
Well, the remarks that he made were, yes, that's correct, he would be immune. So I don't hear any disagreement with you. Do you disagree?
I would disagree with your characterization of how he responded to that question. I think he said it was outlandish, would not happen, and that there would be a process to hold someone like that accountable. And I think
the question from the judge was, if he were not impeached first, is that your position? And that was Sauer's position. It sounds like that is your position as well. Let me ask you about a different part of the court's opinion, that is that the only area where he's truly liable is purely personal conduct. So let me ask you this. If a president uses their official position to enrich themselves, is he immune, or is that purely personal?
So Chief Justice Roberts asked a similar question at oral argument. I think counsel referred him to the...
I'm asking you.
Yeah, I want to refer you to the same place, the United States versus Brewster.
Don't refer me, just answer the question. In your view, if the president enriches himself through his office, is he immune, or is that purely personal conduct?
Yeah, so I think the United States versus Brewster decision said
you're not answering my question. Let me ask you a different one, see if you'll answer that. If a president took bribes to change the country's policy in the Gulf? Purely personal or subject to immunity?
Brewster dealt with bribes, and in that case, the court said that a legislator could be prosecuted for bribery.
We're not talking about a legislator. We're talking about the President of the United States, who has immunity now thanks to your work in part. So let me ask you another question. If a president demanded money from a media organization in order to approve a merger, immune or purely personal conduct subject to prosecution?
Every hypothetical situation will be addressed by the test in Trump versus United States on what type of immunity would apply.
Yeah, so you're not going to answer the question. What if a president falsely arrested a sufficient number of senators such that he couldn't be impeached? Is there a remedy for that?
For each of these hypothetical situations, the Trump versus United States test would be applied.
Okay, the Trump versus United States test would be applied, so the president is using the military to arrest members of Congress to prevent his impeachment. What's the remedy?
In each of these hypothetical scenarios, Senator, the remedy is...
What's the remedy?
The court would go through the different types of presidential power that might be at issue. There's a different test for absolute versus...
He's passed the test. He's got immunity unless he's impeached. That's what the court has held. And he's not impeached because he can't be impeached, because he's arrested enough of the Senate to prevent his impeachment or even an impeachment proceeding. What's the remedy?
So, Senator, as I've said, for each hypothetical scenario you're trying to present, the court would look at the different tests that the Trump versus United States would present.
I'm just going to have to conclude here that you don't want to express your view on it, because I think it's a shocking view. I think it was a shocking view that John Sauer expressed in the Court of Appeals. I think it's a shocking view that you hold, that the president's authority is so profound that he basically is above and beyond the law, that there's no remedy for a president who would abuse his power the way we have already seen and I fear we'll see in the future. I think the Roberts Court will go down in history. That will be their legacy as having enabled the worst form of corruption we've ever seen in the Oval Office. And you'll be a part of the team that made that possible. I yield back.
All right, let's unpack this. If you felt the walls closing in watching that, yeah, that's the correct reaction. Schiff's first hypothetical wasn't a random gotcha. It's the SEAL Team 6 question. Every law professor in America has weighed in on it for 2 years. And Justin Smith, a man who wants a lifetime seat on a federal appeals court, couldn't manage a yes or no. Now, before we get to the next clip, you need to understand the ruling this entire thing is built on. Supreme Court grants broad immunity to former presidents. In a landmark decision, the Supreme Court ruled in Trump v. United States that former presidents have absolute immunity from criminal prosecution for actions within their core constitutional powers. The deeply divided court further determined that presidents are entitled to presumptive immunity for all other official acts, shifting the burden to prosecutors to prove that charging those acts would not intrude on the authority and functions of the executive branch. This ruling has fundamentally reshaped the legal landscape regarding presidential accountability. Critics argue it essentially places the president above the law, creating a dangerous precedent where a commander-in-chief could abuse their power without fear of criminal consequences, leaving impeachment as the sole, often politically fraught, remedy for extreme misconduct. So that's the ruling, 6-3. Justice Sotomayor's dissent put it bluntly. A president, she wrote, is now a king above the law. And that's the backdrop Schiff is working with when he asks his next question. Watch. The SEAL Team 6 hypothetical, testing the limits of presidential power. During intense congressional hearings and appellate court arguments, legal scholars and lawmakers have repeatedly invoked the chilling SEAL Team 6 hypothetical. This scenario asks whether a president who orders the military to assassinate a political rival would be immune from criminal prosecution under the new Supreme Court guidelines. Defense attorneys and conservative legal advocates have controversially argued that unless a president is first impeached and convicted by Congress, such an act could indeed be shielded from criminal liability. This interpretation has sparked outrage among lawmakers like Senator Adam Schiff, who warned that it provides a roadmap for authoritarianism within the American constitutional framework. And this isn't Schiff being dramatic. Trump's own lawyers argued this in open court. A federal appeals court They said out loud that a president could order the military to kill a rival and be immune, unless Congress impeached and convicted first. That's not a quote from cable news. That's from oral argument. A question that used to answer itself now requires a legal test. Now watch the bribery question. This one's the sneakier of the bunch. Bribery and official acts. The blurry line and executive immunity. The recent Supreme Court rulings on presidential immunity have reignited debates over how the law treats bribery when mixed with official presidential duties. In hypotheticals posed by lawmakers, questions have arisen about a president accepting bribes to alter foreign policy, or to approve corporate mergers, actions that ordinarily fall under their official purview. The core legal tension lies in distinguishing between a purely personal criminal act and a corrupted official act. Under the current legal theories advanced by some judicial nominees, prosecuting a president for bribery involving official duties might be impossible unless the political hurdle of impeachment is cleared first, creating a potential loophole for unprecedented Oval Office corruption. So read between the lines. Under the immunity ruling, prosecutors can't even use evidence of official acts to prove a crime. A president takes a suitcase of cash to change Middle East policy, and the policy change itself, the thing he got paid for, becomes legally untouchable at trial. That's not a loophole. That's a blueprint. And Smith, asked directly, says he'd apply the relevant legal tests. He's a federal judge nominee. The test is the bribery statute. It's been on the books for 200 years. Which brings us to why Smith keeps dodging in the first place. Judicial nominees dodge tough questions on presidential accountability. Senate confirmation hearings have grown increasingly contentious as lawmakers press judicial nominees on their interpretations of the limits of presidential power. A common strategy among nominees is to refuse to answer hypothetical questions regarding extreme presidential misconduct, citing ethical obligations not to prejudge cases that might come before their courts. While this adherence to judicial norms is standard, it has frustrated senators seeking clarity on how these future judges would interpret the Supreme Court's newly established immunity tests. Lawmakers argue that refusing to disavow blatant abuses of power, such as politically motivated arrests or assassinations, indicates a dangerous deference to the executive branch. Fine, I get it. The can't prejudge rule is real. Nominees have dodged hypotheticals forever. But there's a difference between not prejudging a close legal question and refusing to say whether murdering a senator with a Navy SEAL unit is against the law. One of those is judicial restraint. The other is a man auditioning for a lifetime seat by proving he won't get in anyone's way. And here's the part nobody's really talking about. Watch Schiff's last question. Congressional oversight in the age of absolute immunity. With the courts expanding the scope of presidential immunity, the burden of holding the executive branch accountable falls heavily on Congress. However, hypotheticals suggesting a rogue president could simply order the arrest of opposing lawmakers to prevent an impeachment vote highlight the vulnerability of this constitutional check. This shift emphasizes the high stakes of current legal interpretations. If criminal prosecution is off the table for official acts, and the impeachment process can be physically or politically subverted by the executive, the foundational American principle of checks and balances may be facing its most severe stress test in history. So here's the line. A federal judge nominee 4 days ago was asked if a president ordering an assassination is a crime, and he wouldn't say yes. That's not caution. That's a resume. If you want more of these breakdowns, the kind that shows you the receipts, hit subscribe, share this with someone who thinks this stuff doesn't matter, and I'll see you in the next one.